to our final session of this conference. And today, the last session, we have a really experienced and knowledgeable scholar from the South Asia Human Rights Documentation Center of India, Mr. Ravi Nair. And the second speaker, Mrs. Angkanani Lapati, the head of Justice for Peace Foundation Thailand. And for this panel, Mrs. Sarita Thadaranchak will be the discussant. She is the director of People's Empowerment Foundation of Thailand. Ladies and gentlemen, please join me in welcoming our speakers today. And now I give the floor to Mr. Nair. Thank you.
It should be that. I'm not speaker. Okay. Never mind. Yes, good afternoon, friend. This session, we will have two speakers, one from South Asia and another one is from Thailand, one lady and also one man. That is very good for me as a discussant. Thank you very much that you also give one lady, one man for this panel. Robina is the most popular human rights activist in South Asia for many years, no? He is the executive director of the South Asia Human Rights Documentation Centers. He started his activism, I think that more than 20 years until now. I think that more than 20 years now. To show, and he's dedicated and also his experience on this issue. I think that it also have the guarantee from award, Human Rights Awards of the M.A. Thomas, National Human Rights Awards from M.A. Thomas, that is also guaranteed with his experience as a human rights activist. He also lectures in many universities, namely Iowa University and also Harvard University. He also working as a technical advisory service program of the United Nations High Commissioner of Human Rights as a training program in Nepal, and also doing the home workshop in America. Oh no, not America. Armenia's of the UN Human Rights Mechanism. So this is not only in South Asia, he also do with the human rights mechanism at the international level. Ravina is also, right now, he also teaching human rights in a law school across university in Asia, and also he also teaching in Mahidol University on human rights curriculum, no, in Mahidol University also. So this is Ravina. We also have another speaker, Kun Angkanani Lapati. Angkana, yeah, she is also Muslim. Huh? She became the human rights activist after her husband, who is human rights lawyer, was kidnapping by the group, by the police, by officer in 2004. She is now the chairwoman of Justice and Peace Foundation. Angkana working very hard to protect the victims of human rights abuses in deep south of Thailand, especially the women victims in southern Thailand. She also got many awards also, no? The mention the name of the award that she also got, you see, no? The Gwangju Prize of Human Rights for May 18, right? May 18 Foundation, and also Women Human Rights Defenders Award from the European Parliament, and also you also got the award from the French President. You also got award from the Senator House as a prominent woman human rights defender. Angkana is also used to be the member of Constitution Drafting Committee and also member of the Constitution Assembly in 2007. And right now she is the member of the ad hoc committee of the evaluation of Southern Thailand peace process in Nether House. So this is Angkana Nilapati. So I would like first to start, Ravina, to share about your very interesting experience as a human rights activist in India. Please, Ravina.
Thank you, Chalinda, for those very kind words. I'm a Faridari. I started my first human rights involvement at the age of 18 with a small organization that disappeared a long time ago called the Bandi Mukti Samiti, which was for the release of political prisoners arrested between 1971 up to 1977 for pro-Maoist activity. It was mainly centered in Calcutta but had a small unit in Delhi University. So it's been a fairly interesting involvement with human rights, from mass organizations to more the NGO variety, and now perhaps meandering back to mass organizations. I'm not popular in India with the state or in other parts of South Asia. I am formally not allowed to enter Sri Lanka. I have problems obtaining a visa in Pakistan. I have to always have some heavy political heft to help me get a visa. And I haven't tested the waters recently in Bangladesh, but I was thrown out both by Ershad and Begum Zia. Formerly in Ershad's time, formally escorted like a VIP to the tarmac and put on the flight. Felt very nice and important. But what I'm trying to say today is the situation in India in particular, but in other parts of South Asia also, with the exception of Pakistan, slightly different. India and Bangladesh and Sri Lanka have lots of similarities. Is that the state is becoming extremely sophisticated and subtle in how it deals with dissent and protest. The Indian state, of course, has 5,000 years of experience of obfuscation. So the Brahminical order can teach the good Mandarinate order a lesson or two on how to deal with dissent. But its uses rather like, unlike Putin's Russia or Mugabe's Zimbabwe, it doesn't use a sledgehammer to deal with dissent. It uses, where necessary, a fly swatter, and where necessary, a surgeon's scalpel. The incisions are very precise, and to that extent much more difficult to deal with. I could not organize a meeting of this kind in New Delhi. I or anybody else could not organize a meeting in New Delhi of this kind. No meeting in New Delhi, according to the official rules, no international seminar, whether it be on ornithology, stamp collecting, or human rights, can be held without governmental permission, without the permission of the Ministry of Home Affairs. The exact circular's words are, no international seminar which is of a political, semi-political, communal or religious in nature or is related to human rights, note human rights in particular separately, can be held in India without permission from the Ministry of Home Affairs. If you have participants, in addition to this, if you have participants from any of the SAARC countries, South Asian countries, or China, separate permission is required from the Ministry of External Affairs in addition to the Ministry of Home Affairs, which is our equivalent of our Ministry of Interior. And I know how difficult it is to get permission on more than one occasion. So in the past, when we did any international meetings, we tried to do them in Bangkok or went to Kathmandu. So it gives you an idea of the kind of playing field that you are faced with immediately as an NGO involved in any attempt at regional or international work. Then comes the national domestic scenario. Fortunately, the tradition of dissent and protest is a very deep, long-standing vein that flows within India. It's not suddenly that's come and erupted. In fact, we have a 16th century saying from eastern UP, from Valia in eastern UP, a hotbed of protest even under the Mughal rulers and until today, which says, Dilli uncha sunta hai, meaning Delhi is hard of hearing. If you don't mumble and grumble, nobody is going to listen to you in the corridors of power. And I think it is that tradition of protest, of dissent, that has kept Indian democratic values and traditions alive, rather than just the mere constitutional framework. The constitutional framework has put the imprimatur of legal approval on this and is extremely important. And I'll tell you, I'll come to that in greater detail subsequently. During the anti-colonial struggle against the British, civil liberties was a major vein in the struggle. In fact, the Indian Civil Liberties Union was formed in 1934, and the first Prime Minister of India, Mr. Nehru, was its first president, and the first leader of the very powerful then Socialist Party, which was the main opposition party in the 1950s and 60s, was its first General Secretary. However, the Indian Civil Liberties Union was disbanded officially by the Prime Minister in 1950, saying that now that we had ourselves a democratic constitution with fundamental rights spelled into the constitution very clearly, there was no need that the state would protect civil liberties and human rights, and there was no necessity for efforts in society. But these fears were, these promises were not kept, and almost immediately after independence, we brought one of the most draconian preventive detention laws, the PD Act, the Preventive Detention Act. Until that point of time, the only constitution which had preventive detention written into the constitution was Mexico. After all, you had that crazy party there called the Institutional Revolutionary Party, which ruled on and on and on forever and ever. So they had preventive detention. We were the first new post-Second World War state which had preventive detention, not written as emergency law, not having sunset clauses, not subject to ratification by Parliament or a legislature periodically, but written into the Constitution as part of the permanent scheme of things. This was very problematic, and the courts, unfortunately, were very reluctant to question the state's prerogative in this area. It took the anti-Maoist repression of the 70s in a big way, where people tend to forget in India, and of course internationally there is just no memory of it, 100,000 plus, and I'm not being exaggerated, 100,000 plus young people were extrajudicially executed in the states of West Bengal, Andhra Pradesh, Assam, Bihar, and what is now the states of Madhya Pradesh and Chhattisgarh in central India. in cold blood. They were just taken next to an irrigation canal, and a bullet was put through the head, and what we euphemistically call encounter deaths in India. No real investigation was ever conducted except briefly in 1977 by a new government that replaced the Congress government, called the Bhargav Commission report in the state relating to extrajudicial executions in the state of Andhra Pradesh. But no action was taken by, though a fairly comprehensive and substantive report was given by Justice Bhargav on the nature of extrajudicial executions. The most broadest civil liberties organization that we have in India today is the People's Union for Civil Liberties. The People's Union for Civil Liberties is a mass movement. It has no donor support. It refuses to take any donor support. And for that reason, many of its state units, the quality varies according to the state, have been on the front line, and even though they've got a battering, they've been able to spring back and fight for civil liberties in a very effective manner. Similarly, many of the smaller organizations, like the People's Union for Democratic Rights, which takes a much more broader view of human rights rather than the restricted view on civil and political rights, but more into economic, social and cultural rights. They have also formal policy of not taking any international donor money, and to that extent have been insulated from a lot of the intrusive scrutiny of the state that the state has put across on NGOs which have got international support, but who now seek to push the envelope on a number of areas. And so the state is attempting to control this. When Pinochet brought legislation to stop the international community and the Catholic Church in particular to stop funding to that wonderful church organization called the Vicaria de Solidaridad, which did all the documentation and research on the Pinochet dictatorship's repression, Europe was up in arms. And fortunately also the fact that Carter took over in January of 1977 and had a much more human rights friendly regime forced the Pinochet regime to backtrack on the law which was basically aimed at the Vicaria, but a lot of other community organizations. If you also recall, the apartheid South Africa had an attempt to stop funding, mostly Swedish funding, but also from other smaller countries, funding to the community organizations in Soweto and other places. Again, if you remember, there was Mr. Botha, who was then the foreign minister. They had to beat a retreat because by then the Afro-American caucus in the US Congress and Senate had become much more powerful, and you saw a major shift in US policy towards South Africa, which until then was quite ambivalent, not as cozy and lovey-dovey as Maggie Thatcher's little cordial entente with the apartheid regime, but clearly sympathetic. But there was a marked shift with the new power that the Afro-American Congressional Caucus wielded. At about the same time, we had an emergency in India. In 1975, it was promulgated, a period of authoritarian rule where elections were postponed, where a large number of activists were put in jail. I also was a guest of the government for a year during that period. And we then had this new law attempting to stifle the Gandhian organizations which were protesting against the undemocratic edifice in place. and Mrs. Gandhi, Indira Gandhi, brought about a law called the Foreign Contribution Regulation Act. The law still exists on the statute book. It's much more powerful and much more amended many times since, and much more powerful in terms of how it controls all civil society activity which gets foreign assistance. But the attempt to do intrusive scrutiny of civil society is not restricted to those who are donor supported. It is also under the Registration of Societies Act, under the Indian Trust Act, under the Indian Charities Act, that if I got a donation from an Indian businessman, I will have to have separate registration under 12A or 80G of the Income Tax Act to get money from a local philanthropist. And the local philanthropist is very mindful of the intrusive scrutiny that he or she will face if he suddenly gives it to activity which the state feels is not kosher, which is not. And I've had friends from university who are industrialists tell me that, I'm sorry Ravi, we would like to help you, but I have a license application pending for a new plant in wherever, and I don't want the file to be sat on for a few months or years or whatever else. We then have new laws which have accentuated this already legal armory that the state has in trying to control voluntary action. We have in the state of Madhya Pradesh, which is also applicable in the adjoining state of Chhattisgarh, which was earlier part of Madhya Pradesh, a very large state with a large tribal population, indigenous population, a law called the Madhya Pradesh State Security Law. Now, that law, ostensibly to fight the Maoist threat in that area, has such catch-all provisions, such broad provisions, which make almost all civil society action punishable. In fact, if Gandhi were alive enough to go to Madhya Pradesh, civil disobedience under that law, which Gandhi practiced, would be a major crime, and he would spend as long as 10 years in jail under that law, under section 2E of the law. So it is unlawful activity is defined very broadly by saying which constitutes a danger or menace to public order, peace and tranquility. That is subclause 1. Subclause 2 is which has interfered or tends to interfere with the maintenance of public order. Or subclause 3, which has interfered or tends to interfere with the administration of law or is established institutions or persons. Now, the 4th and 5th clause I can understand, which relates to violence. I can understand that because of the Maoist threat of, indulging in or propagating acts of violence, terrorism, etc., etc. Or the 5th one, encouraging the use of firearms, explosives. But the 6th one is even more bizarre, which is of encouraging or preaching disobedience to established law and its institutions, which flies in the face of Article 9.1 of the Constitution, which allows us to form any kind of association or mass organization to peacefully protest. So this law is still on the statute book. It's been challenged, but the courts have not yet found time to go forward with the hearings on this particular legal challenge, so we are faced with it. And while a prominent doctor who was arrested under this law was freed on bail by the Supreme Court after being convicted by the trial court, is out on bail. There are hundreds of tribal activists who are not Maoists. They are tribal activists saying that alienation of their land by big corporate houses and corporate contractor interests must stop have been arrested. Those who've been asking for the government proclaimed minimum wages for minimum prices for forest produce be paid have been arrested, and a range of other activists working on what one would call giving implementation to the government's own legislative process in the economic and social area. A legitimate activity has been criminalized by the local states in this area. There has been a complete attempt at crushing, eroding, diminishing the role of mass organizations. One of the key strengths of the anti-colonial movement, of the Indian independence movement, was the participation of huge peasants and farmers and women's and other mass organizations, trade unions in that movement. Today the trade unions are a shadow of what they were. In an earlier incarnation I used to be a trade unionist. I used to head the Social Democratic Trade Union in India, the General Secretary. But today the trade unions are a shadow of themselves. They've been completely scuttled. None of the ILO conventions relating to collective bargaining or freedom of association have been signed by India, and there's never been any international outcry about it or any great hoo-ha about it. On the flip side, there's been an attempt, at least in the 80s and 90s, by the state to allow the proliferation of non-mass organizations, what we would call NGOs in today's parlance. They were fine as long as they stuck to developmental activity. They were fine as long as they stuck to even areas which the state did not like, or it brought the state bad publicity. Here India was more sophisticated than Putin or Mr. Mugabe. But as long as it did not challenge what the state saw as its core areas of competence, sovereignty or security of the state, that was no-go area, that was verboten area. So you entered that area at your peril. You also did not enter certain geographical areas. So the state very clearly told you that if you went into these areas, things that are very bad could happen to you. So you could attack us on custodial debts in Delhi. You could even attack us on custodial debts in Andhra Pradesh, in the south. If you talk to us about custodial debts in Kashmir or Nagaland or Manipur, well, woe betide you. Now some of us clowns didn't read the signals, and clearly we've had more than one problem. The NGOs now, both donor supported by both government agencies, private agencies and international donors, have all now been very careful on this area. So the state has not had to formally legislate on this area, though it does have the provisions of the Foreign Contribution Regulation Act to bring you into line. A lot of it is done by just waving the stick. So you immediately do a lot of self-censorship. So a large number of very good NGOs working on child rights, for example, doing excellent work on child rights, somehow do not want to address the issue of children in armed conflict in Kashmir or in Manipur. That's the minute you do it at the field level. The government is again very sophisticated. It doesn't mind seminars. You can do as many UNESCO or UNICEF supported seminars, as long as you sit in a 5-star hotel like this one and talk as much as you want to. The government is cool, let them, calibration for their gullet. But don't go to this area, don't litigate on behalf of children in prisons, children in conflict with the law, children in difficulty with the law. That is wrong number. So we had the absurd situation in 2010 when 46 children between the ages of 12 and 16 were killed in Kashmir by police and army firing, where the Prime Minister himself came out publicly and expressed anguish. He's a decent man. He expressed anguish. But the major child rights organizations all got an attack of laryngitis. They did not speak up on that particular issue, which took place from March to September of 2010. It was the children's crusades for all practical purposes in Kashmir. Nobody was throwing grenades, they were definitely throwing stones. But they were shot at with a shoot to kill policy, not a shoot to maim or shoot to frighten. So you can see how the state has made sure that you do not cross the Rubicon in a number of areas. It's forced NGOs to behave. Even organizations which had a prior history of activism, once they got co-opted into this, either states funded or donors funded or private funded by Indian corporate interests, they became slowly tame. So from tigers, many of them in the 50s and 60s, became pussycats in the 2000s era. And you saw the state becoming much more comfortable. I think we were the originators of gongos. Everybody else, the term gongo came first into the parlance in India. It was picked up in '93 in the Vienna World Conference by everybody else and popularized. If you want to go into the history, I can give you some notes on that. But the Indian state really realized that it must also enter the funding business and create its own setup. So it set up an organization called CAPART, the Center for Promotion of Rural Activities and Technology, or some esoteric name like that, which is now the largest funder in India of civil society, not international donors, which very few people even in India know about. It is the largest. The state controls a lot of the developmental interventions by civil society in India. The earlier elan and enthusiasm of a range of mass organizations of religious nature, like the Catholic Church or Hindu organizations or any other denomination, Buddhist organizations working on a range of issues, has disappeared. Today, for example, in the anti-nuclear struggle in the south in India, in a place called Kudankulam, which is on the tip of India, where the majority of the population is Catholic by religious persuasion, all it needed was for the bishop to be issued a notice under the Foreign Contribution Regulation Act. The Catholic Bishops' Conference of India's secretary to be called in for a meeting to Delhi at the FCR, at the Home Ministry, and gently reminded of the FCRA and said that we could look at a wider funding of the Catholic Church's activities if you desisted from making sure that all the parish priests in that area did not aid and give support and succor to the people agitating against the nuclear power. Fortunately, even though the Catholic Church retreated under this threat, because of the mass nature of the protest, of the complete support that every village in that area supported this agitation, the state hoisting on one particular activist, over 600 cases. Many others having an average of 60 to 65 cases. But this particular activist having 600 cases. Okay? 600. And these are not civil cases, these are criminal cases which require you to go to a magistrate for hearings on a regular basis. So basically it's scuppering any time that you have of doing anything else except hanging around the courts. The activist is an extremely brave individual, and he said, okay, I'll take you guys on, and he's still fighting God's own good fight against the nuclear project there. My problem is the donor-supported NGOs which have done very good work in a number of areas. Today, there is now a law of diminishing returns thanks to the state's intrusive scrutiny. They are not willing to go beyond a certain point. When they go beyond a certain point, the state comes down heavily. 2 years ago, 13 NGOs lost their registration under the Foreign Contribution Regulation Act. Earlier this year, 2 major NGOs, INSAF and People's Watch Tamil Nadu, Chalita knows them quite well, lost their FCRA registrations. NGOs also are put out, were put out, many NGO activists were put on a list called LOC, Look Out Card list, including me, where if I entered and left the country, the Intelligence Bureau had to be informed that I was leaving and entering the country. My LOC is now not done overtly, it's done covertly. They do it more sophisticated manner because it was raised in Parliament, and parliamentarians yelled at the Home Minister saying, what the hell, what's wrong with you guys? We know this guy for long enough. He's been a troublemaker for long enough, but he's no anti-national. But now everybody doesn't have friends in Parliament. Thanks to my political past, I have many friends across both sides of the divide. But there is a chill running through the spine of NGOs on doing any activity which is seen as challenging the security of the state. The issue of how the state is controlling donor activity is also, as the Indian state becomes more confident. 5 years ago, it called in all the major bilateral organizations, not the multilateral UN organizations, but the bilateral organizations, and told them they could pack their bags and go. Just told them fine morning, thank you very much, we can pack things. The EU was going around like a bunch of chickens, and they flapped their wings and they did what they do, quack, quack, quack. And finally, the German Overseas Aid Organization, the USAID, the British aid organizations were allowed to stay with their offices. All the other smaller ones, the Daniders and the Cedars and all, were basically told to wind down their activity and leave. So they're all in the process of winding down their activity and leaving. Now the government, of course, uses it as a carrot and stick. Besides, when Denmark, as chair of the EU, makes sure that human rights is no longer on the bilateral EU summit, then Denmark is allowed to continue with its activity. But if you raise the issue of human rights in the EU bilateral with India, sorry, Nong Ramna, the Joint Secretary in charge of Western Europe will call in the head of the EU at that particular point of time, embassy here, and say, oh, you're Dane, aren't you? Oh, you have that Holder Topsoe contract with our public sector company. I think Holder Topsoe needs to be reviewed. And so the Danes get the message, and of course, the Dutch get the message, everybody is antiseptic. So you yell and mumble and grumble about Mugabe, and you suddenly become human rights impresarios when it comes to Mugabe. Well, he does deserve it, but you suddenly get a major sore throat when it comes to India, because India knows how to exercise the carrot and the stick. They've taken a lesson from the Chinese. This is the Chinese problem. This is one lesson that the Brahminical hierarchy in India learned from the Mandarin age, and they've used it with great efficacy. What do we do in this situation? We are now in a very difficult situation. We are in a difficult situation where small organizations like the Andhra Pradesh Civil Liberties Committee has their offices regularly raided, their activists regularly arrested, their phones heard into, their emails opened regularly, their correspondence steamed open, and they don't even bother to stick them back together. They just say, here, if you want it, take it, otherwise you can throw it away. Or Manav Adhikar Sangram Samiti, Human Rights Struggle Committee in Assam, has major problems. What do we do with them? So many of us have been thinking that the only way is go back to mass organizations. That the Kudankulam struggle, anti-nuclear struggle, has reminded us of the anti-colonial past struggle. That our staying power, our fighting power, our ability to go forward is incumbent on our social base and not on our watches of donor money. It is, do we have mass support? Do we have social base? Will the community stand up for us? Because when the 13 NGOs lost their FCRA registration, there wasn't a squeak. There were a few protests for 3 or 4 days by the converted, speaking to the converted. So it was in a little cabal. But beyond that, in terms of yelling and mumbling in the public domain, there wasn't. Whereas when they hit the Kudankulam and protested, thousands and thousands of people came out on the street across the state of Tamil Nadu, not nationally, across the state of Tamil Nadu, and said, if they are anti-national, so are we. And the state had to go slow on the prosecutions. It's not lifted the Damocles sword, but has understood that politically it would be extremely expensive in the next parliamentary elections in 2014 to the ruling party's prospects in the 3 southern districts in question. So I think there is an attempt to do that. Second, the government is now creating a large number of not just Congos, but informal NGOs. The Foreign Contribution Regulation Act is not monitored by the Finance Ministry. It is administered by the Intelligence Bureau of the Government of India. The official who comes to see you and your accounts is not an auditor. He is a highly official, he is an Intelligence Bureau official. He knows as much about finances as I know about nuclear physics. But he's learnt on the job. They do get expertise and outside consultants, and they've hired a few people. But broadly, it's people who want to make sure that you know that they know that they're watching. And in the process, they attempt to recruit your staff members, your membership, as informers of the Intelligence Bureau. Like most of Asia, there is no parliamentary or legislative scrutiny on the Intelligence Bureau in this country, in India. There is no financial auditory controls by the Comptroller General or the Auditor General of India. So the Praetorian Guard is sometimes more powerful than Caesar. And I am not being facetious in this. I know very well because I've been at the receiving end for many years, and this is the last battle of my life to get parliamentary control on the intelligence machinery in India. So large number of NGOs are now working closely with the intelligence. One Western India NGO, which has the word civil liberties on its letterhead, files all the cases against the Narmada Bachao Andolan and the anti-dam movement and the tribal movement, and against the civil liberties organizations in the state of Gujarat who are fighting for justice of the victims of the anti-Muslim pogroms in Gujarat, all sorts of frivolous cases to scupper their activity. Similarly, I went through a huge process which I've just got out of after the state did a lot of funny business with me, and finally the courts have told me, okay, we let you off, and they've got nothing against you. Ave Maria to that. And it was 10 years of hell. 10 years of sheer hell. But I'm still here and around and still punching. But if I did not have the large amount of support that I had, thanks to my range of other activity outside my formal NGO hat, I would have been obliterated. Because I had friends in the political world, I had friends in the artistic world, I had friends in the parliament, I had friends even in the state apparatus who would want me, and outside the country to a limited extent. I should let you in on a secret. It will be the European Ombudsman is investigating certain EU officials presently for an unholy dalliance with Indian intelligence officials. And though I am not technically an EU citizen, the evidence I provided was of such great importance and such a great shock to him that he has opened what is called an own initiative inquiry. Because technically I am not an EU citizen, I am not subject to being able to prefer a complaint. But I was able to show the documents of how the Intelligence Bureau had suborned the loyalties of a few junior officials in the EU machinery to fix little Charlie. And they almost fixed me, Charlie, without the fact that I had friends in European civil society who were willing to stand up for me and organize the best legal defense to me. To cut a long story short, on the outside, India is the largest parliamentary democracy. But we are like the false front in a theatrical production. There's a nice stage set, but behind the props, there's nothing. It's all wooden stills, and very weak wooden stills. So you don't lean on the props, otherwise they'll go tumbling down. There is a certain sense of helplessness because even the courts have refused to go beyond a certain point when it comes to what is national security. And I'll conclude with that. For example, some of us brought in the state of Andhra Pradesh a petition attempting to have mandatory judicial inquiries against extrajudicial inquiries. A single member bench headed by a very good judge gave us a very good decision, saying that there must be mandatory judicial inquiries in all cases of custodial and deaths and extrajudicial executions. In spite of Supreme Court guidelines being existent prevalent prior to that effect. The Police Association challenged it. It went to a double-member bench of the High Court, which is a superior court in India, which upheld the single-member bench in our favor. The Police Association went to the Supreme Court. It's been pending for the last 5 years there. It's been admitted. A stay order has been granted against the Andhra Pradesh High Court, and no hearings have been held in the Supreme Court on something which is so germane to democratic life of any country, the life and liberty of the citizen. I always tell friends abroad that in 1978 we passed the 44th Amendment to the Indian Constitution, which made authoritarian rule and emergency much more difficult to proclaim. Almost all the clauses were implemented, except the safeguards on preventive detention, where there was the advisory boards on preventive detention had to be, according to the amendment, composed of judicial officers, or former judicial officers, and no executive officers. That has not been gazetted until today. This is the year of the Lord, 2013, soon to be in 2 days, 2014. The amendment went unanimously through Parliament in 1978. This was brought to the attention of the Supreme Court in a very famous case called the A.K. Roy case. The Supreme Court refused to look at it and just said, look, we are only dealing with the particular case of Mr. Roy here. Parliament can deal with that if the executive is not notified or gazetted that particular provision. So we are stuck with inadequate protection. And in states like Kashmir, where you can be held at 2 years at a stretch in preventive detention and constantly re-promulgated, and just you get out of the prison and you're brought back in. You don't even spend 2 minutes outside. Another posek puts you in back again. It's a completely ridiculous case. This is the condition in which NGOs are. So next time you think about democracy and NGO freedoms, spare a little thought for some of the smaller NGOs in India. We speak English, we understand the international world, we have a certain amount of protection. But these Soni Soris, a woman tribal activist, who had stones put into her private parts, thrust into the police, and the Supreme Court refused to believe it in spite of the forensic medical report to supporting it, is what the situation the average activist faces. The average young Muslim arrested allegedly for anti-terrorist activity is jailed for 5 years, 6 years, 7 years, 8 years. Released after 8 years saying, sorry, we made a mistake, thank you very much, please go home. No compensation, no apology for the fact that 8 years of my life were taken away. We have no mandatory compensation in India. India has made a reservation which is euphemistically called a declaration on the right to compensation under the International Convention on Civil and Political Rights, which has not been agitated adequately. So we have lots of problems. So I would like, the donor agencies are very careful, with the exception of the North Americans. And I'm being very blunt and honest here. The Europeans have genuflected when the government of India has asked them to bend. They just crawled. North Americans have stood their ground, but are not speaking as forcefully as they did in the past. They're speaking in much more feeble voices. Let me finally end by just saying that thank God for President Carter, in spite of the Bush's administration and the Obama administration's attempt to dilute the annual human rights report of the State Department. It is a proper reflection of what it is really to do. Read that much more than the UN's documents. The UN today is, in India, a fairly ineffective body. Thank you very much.
I would like to continue the presentation about the topic that she will share with us is about the implementation of human rights in challenges and perspective.
Thank you so much, Sharida, and good afternoon, everybody. I will speak about the implementation of human rights in Thailand, the challenges and perspective. I will try to speak fast, and I welcome all of your questions and comments. I think I prefer to speak in Thai, and yeah, I will start with the situation of the human rights in Thailand, and then I will talk about the obstacles and challenges. ก็ดิฉันจะพูดในภาษาไทยเลยนะคะในฐานะที่เป็นคนไทยแล้วอยู่ในเมืองไทยฉันขอพูดเป็นภาษาไทยนะคะดูเหมือนว่าสถานการณ์สิทธิมนุษยชนประเทศไทยเนี่ยจะก้าวหน้ามากกว่าหลายๆประเทศในเอเชียนะคะประเทศไทยเนี่ยจนปัจจุบันนี้เนี่ยประเทศไทยได้ลงนามในอนุสัญญาระหว่างประเทศเรื่องสิทธิมนุษยชนทั้งสิ้น7 ฉบับด้วยกัน นะคะไม่ว่าจะเป็นกติกาสากลว่าด้วยสิทธิพลเมืองและสิทธิทางการเมืองนะคะอนุสัญญาว่าด้วยสิทธิทางเศรษฐกิจสังคมวัฒนธรรมนะคะอนุสัญญาต่อต้านการจัดการเรื่องปฏิบัติต่อสตรีทุกรูปแบบนะคะอนุสัญญาว่าด้วยสิทธิเด็กนะคะแล้วก็อนุสัญญาว่าด้วยการขจัดการเลือกปฏิบัติทางเชื้อชาตินะคะอนุสัญญาว่าด้วยการต่อต้านการทรมานนะคะแล้วก็อนุสัญญาว่าด้วยสิทธิของคนพิการนะคะและเมื่อเดือนมกราคมที่ผ่านมาเมื่อปี 2012 เนี่ยประเทศไทยก็ได้ลงนามในอนุสัญญาว่าด้วยการบังคับให้บุคคลของสัญชาตินะคะอย่างไรก็ดีเนี่ยประเทศไทยก็มีประวัติยาวนานนะคะในเรื่องของการใช้ความรุนแรงจากรัฐนะคะถ้านับไปในเวลาประมาณสัก60 ปีนะคะหรือตั้งแต่ปี 1950 เนี่ยเราพบเหตุการณ์การละเมิดสิทธิมนุษยชนร้ายแรงเกิดขึ้นในประเทศไทยมากมายนะคะไม่ว่าจะเป็นเรื่องของการบังคับให้สูญหายการสังหารนอกกระบวนการยุติธรรมการควบคุมตัวตามอำเภอใจนะคะการซ้อมทรมานนะคะแล้วก็รูปแบบอื่นๆของการละเมิดสิทธิมนุษยชนนะคะอย่างไรก็ตามเนี่ยเราก็ยังพบปัญหาอุปสรรคที่สำคัญมากประการหนึ่งก็คือเรื่องของการงดเว้นโทษยังคงเกิดขึ้นนะคะเราพบว่ามีกฎหมายหรือหลักเกณฑ์การปฏิบัติในประเทศไทยเนี่ยที่ยังเป็นอุปสรรคกับการที่จะนำคนผิดมาลงโทษตามกระบวนการยุติธรรมนะคะเช่นยกตัวอย่างเช่นในรัฐธรรมนูญของประเทศไทยเนี่ยได้พูดถึงสิทธิของผู้ถูกกล่าวหานะคะเช่นผู้ถูกกล่าวหามีสิทธิ์จะไม่ให้การนะคะมีสิทธิ์ที่จะพบทนายความเป็นต้นแต่ว่าในทางปฏิบัติเนี่ยเรายังมีปัญหามากมายนะคะเช่นเจ้าหน้าที่บางคนเนี่ยก็ยังใช้วิธีการบังคับขู่เข็นให้ผู้ต้องหารับสารภาพแต่เรามีความซับซ้อนยิ่งกว่านั้นก็คือเมื่อผู้กระทำผิดเนี่ยเป็นเจ้าหน้าที่ของรัฐหรือผู้ปฏิบัติตามคำสั่งของเจ้าหน้าที่รัฐเนี่ยก็พบมีการเลือกปฏิบัติระหว่างผู้ต้องหาที่เป็นประชาชนทั่วไปกับผู้ที่เป็นเจ้าหน้าที่นะคะเช่นกรณีที่เจ้าหน้าที่รัฐเป็นตกเป็นผู้กระทำผิดเนี่ยเจ้าหน้าที่มักปฏิเสธที่จะไม่ให้การไม่ให้ข้อมูลในชั้นสอบสวนนะคะเจ้าหน้าที่บางคนหรือหลายคนหรือแทบทั้งหมดปฏิเสธในการที่จะให้มีการตรวจพิสูจน์นะคะเช่นปฏิเสธการให้มีการนำตัวอย่างเลือดหรือเหงื่อนะคะหรือสิ่งอะไรภายในของเขาเพื่อไปหา DNA ในการที่จะเปรียบเทียบนะคะกับเหตุการณ์การละเมิดสิทธิมนุษยชนนะคะจึงทำให้ปัญหาเหล่านี้จึงทำให้เป็นอุปสรรคสำคัญในการที่จะหาพยานหลักฐานในกรณีที่เจ้าหน้าที่เป็นคนผิดนะคะดังนั้นเนี่ยถ้าเราจะมาดูในมิติของความขัดแย้งและความรุนแรงในประเทศไทยนะคะที่ผ่านมาเนี่ยเราคงพูดได้ว่าวันนี้เนี่ยประเทศไทยเนี่ยนะคะเรามีแนวโน้มที่ดีคือมีการนิยามความมั่นคงของประเทศแบบใหม่คือมองถึงความมั่นคงของมนุษย์ควบคู่ไปด้วยแต่ที่ผ่านมาเนี่ยเราจะยึดหลักของความมั่นคงของรัฐเป็นหลักใหญ่โดยไม่ได้มองถึงความมั่นคงของมนุษย์ที่อยู่ในรัฐนั้นนะคะแต่อย่างไรก็ดีเนี่ยถึงแม้นโยบายของสภาความมั่นคงแห่งชาติเนี่ยภายในระยะเวลา 4-5 ปีที่ผ่านมาเนี่ยจะให้ความสำคัญของความมั่นคงของมนุษย์ด้วยก็ตามเนี่ยแต่เรายังพบว่าผู้คนที่อาศัยอยู่ตามชายขอบของประเทศนะคะหรือเป็นชนกลุ่มน้อยก็ตามเนี่ยคนเหล่านี้เนี่ยก็ยังตกเป็นเป้าที่จะถูกไล่ล่าหรือจะถูกคุกคามนะคะจากกฎหมายหรือจากวิธีการปฏิบัติหลายอย่างของเจ้าหน้าที่รัฐปัจจุบันนี้ประเทศไทยเนี่ยนะคะมีความขัดแย้งทั่วไปและความขัดแย้งที่เกิดขึ้นเนี่ยมันก็นำมาซึ่งการละเมิดสิทธิมนุษยชน นะคะถ้าเรามองในทางกลับกันเนี่ยการละเมิดสิทธิมนุษยชนที่เกิดขึ้นในสังคมไทยเนี่ยก็นำพาสังคมเข้าสู่ความขัดแย้งอีกนะคะดังนั้นเนี่ยทั้งความขัดแย้งและการละเมิดสิทธิมนุษยชนในประเทศไทยเนี่ยจึงเป็นเหมือนกับวนเวียนกันอยู่โดยที่เราบางทีคนไทยเองก็ยังไม่รู้ว่าเราควรจะแก้ไขสิ่งใดก่อนนะคะที่ผ่านมาเนี่ยมีนโยบายสำคัญของรัฐนะคะ2 ประการซึ่งทำให้เกิดการละเมิดสิทธิมนุษยชนครั้งใหญ่ๆในสังคมไทยนะคะอันแรกก็คือนโยบายการปราบปรามการก่อการร้ายในจังหวัดชายแดนภาคใต้นะคะซึ่งเริ่มตั้งแต่ปี 2001 เป็นต้นมานะคะและนโยบายที่2ก็คือนโยบายการปราบปรามยาเสพติดนะคะที่เริ่มตั้งแต่สมัยพลตำรวจโททักษิณชินวัตรเป็นนายกรัฐมนตรีซึ่งในช่วงของการปราบปรามยาเสพติดนั้นเนี่ยเราพบว่ามีคนจำนวนมากกว่า 2,500 คนที่ถูกสังหารนะคะถูกอุ้มหายหรือถูกซ้อมทรมานเป็นต้นไม่ต่างจากเหตุการณ์ในภาคใต้นะคะซึ่งไม่ว่าจะเป็นรัฐบาลทักษิณหรือรัฐบาลอภิสิทธิ์ที่ผ่านมาจนปัจจุบันเนี่ยมีผู้คนถูกสังหารไปแล้วเนี่ย 5,000 กว่าคนนะคะซึ่งรวมถึงผู้หญิงและเด็กด้วยแล้วก็ยังไม่มีแนวโน้มว่าเหตุการณ์ความรุนแรงนี้จะยุติได้เมื่อไหร่ในเรื่องของการละเมิดสิทธิมนุษยชนที่เกิดขึ้นในประเทศไทยนะคะเรื่องของการอุ้มฆ่าในประเทศไทยเนี่ยมูลนิธิที่ทำเพื่อสันติภาพเนี่ยได้ทำการบันทึกนะคะในปีที่ผ่านมาเราได้ทำงานวิจัยชิ้นหนึ่งนะคะคือเรื่องชื่อว่าเรื่องสถานการณ์การบังคับซื้อขายในประเทศไทยเราได้บันทึกผู้ที่ถูกอุ้มหายเนี่ยมากกว่า 90 กรณีนะคะในช่วง 10 ปีที่ผ่านมานะคะแล้วเราก็พบว่าบุคคลที่ตกเป็นเป้าของการถูกอุ้มหายเนี่ยนะคะก็มักจะเป็นคนซึ่งมีแนวโน้มที่จะถูกคิดว่าคนเหล่านี้เป็นผู้ต่อต้านรัฐนะคะนักสิทธิมนุษยชนนะคะหรือคนที่เคยทำงานกับรัฐเองนะคะอาจจะเป็นในฐานะสายลับหรืออะไรก็แล้วแต่เนี่ยแต่วันหนึ่งคนเหล่านั้นก็ถูกทำให้หายไปแล้วเราก็ที่น่าสังเกตแล้วก็น่าเป็นห่วงอย่างยิ่งก็คือในกรณีผู้ถูกบังคับสูญหายทั้งหมดในประเทศไทยเนี่ยไม่เคยมีสักกรณีเดียวที่จะสามารถสืบหาตัวผู้สูญหายแล้วก็นำคนผิดมาลงโทษได้ในส่วนของการควบคุมตัวตามอำเภอใจเนี่ยประเทศไทยก็ยังมีกฎหมายพิเศษที่ยังใช้อยู่นะคะซึ่งเป็นกฎหมายที่ทำให้เกิดการละเมิดสิทธิมนุษยชนนะคะโดยเฉพาะในพื้นที่ภาคใต้ที่อยู่ในสถานการณ์ของความขัดแย้งทางอาวุธเนี่ยวันนี้เรามีกฎหมายพิเศษที่ใช้อยู่3 ฉบับด้วยกันนะคะเรามีกฎอัยการศึกนะคะเรามีพระราชบัญญัติพระราชกำหนดการบริหารราชการในสถานการณ์ฉุกเฉินแล้วเราก็ยังมีกฎหมายความมั่นคงนะคะในส่วนของพระราชบัญญัติกฎอัยการศึกเนี่ยปีหน้าเนี่ยก็จะครบ100 ปีที่พระราชบัญญัตินี้ได้ถูกประกาศใช้ในประเทศไทยโดยที่จนปัจจุบันเนี่ยนะคะพระราชบัญญัตินี้ยังไม่เคยมีการปรับปรุงนะคะกฎอัยการศึกนะให้อำนาจกับเจ้าหน้าที่รัฐเนี่ยในการควบคุมตัวประชาชนได้7 วันนะคะโดยไม่ต้องมีหมายศาลนะคะโดยไม่ต้องแจ้งข้อกล่าวหาโดยไม่ต้องแจ้งข้อสงสัยใดๆและสามารถที่จะนำตัวไปควบคุมในสถานที่ที่ไม่ใช่สถานที่ของรัฐนะคะเช่นเรือนจำได้ดังนั้นเนี่ยในงานวิจัยที่ผ่านมาเราพบว่าประชาชนส่วนใหญ่เนี่ยจะหายไปในช่วงของการที่ใช้กฎอัยการศึกนะคะเช่นมีการนำตัวอยู่7 วันแล้วก็หลังจากนั้นเขาก็ไม่ได้กลับบ้านนอกจากนั้นเนี่ยพระราชกำหนดการบริหารราชการในสถานการณ์ฉุกเฉินเนี่ยก็ให้อำนาจเจ้าหน้าที่ในการควบคุมตัวประชาชนได้ครั้งละ7 วันแต่ไม่เกิน30 วันนะคะโดยไม่ต้องมีการแจ้งข้อกล่าวหานะคะตรงนี้เองเนี่ยก็สามารถที่จะทำให้ใครก็ได้นะคะที่อาจจะเป็นเพียงผู้ต้องสงสัยหรืออาจจะเป็นคนที่เจ้าหน้าที่เนี่ยไม่ไว้วางใจเนี่ยถูกนำตัวมาควบคุมได้นะคะทั้งหมดเนี่ยทั้ง2 พระราชบัญญัติเนี่ยจึงทำให้ประชาชนทั่ว เขาไม่จำเป็นต้องมีข้อกล่าวหาอย่างอื่นนะคะนอกจากนั้นเนี่ยกฎหมายความมั่นคงภายในประเทศเนี่ยก็ยังให้อำนาจกับเจ้าหน้าที่นะคะในการที่จะสามารถขอให้ศาลเนี่ยสั่งให้ผู้ต้องสงสัยเนี่ยเข้าไปรับการอบรมหรืออยู่ในการควบคุมได้นะคะในระยะเวลา4 เดือนถึง 6 เดือนนะคะสิ่งเหล่ากฎหมายฉบับ3 ฉบับนี้เนี่ยก็ถือว่ามีความสำคัญมากนะคะเพราะว่าที่ผ่านมาเนี่ยมีการบังคับใช้ในชายขอบของประเทศไทยนะคะไม่ว่าจะเป็นชนเผ่าพี่น้องชนเผ่าที่เป็นชาวเขาชาวภาคเหนือนะคะแล้วก็ในภาคใต้นะคะแล้วก็ทำให้หลายคนเนี่ยต้องสูญเสียอิสรภาพในเรื่องของการทรมานเนี่ยประเทศไทยได้ลงนามอนุสัญญาว่าด้วยการทรมานตั้งแต่ปี 2550 นะคะอีกไม่กี่วันเนี่ยเราจะเข้าปีใหม่ก็ถือว่าเกือบ7 ปีมาแล้วนะคะที่ประเทศไทยได้ลงนามอนุสัญญาฉบับนี้แต่ประเทศไทยยังไม่ได้มีการแก้กฎหมายภายในให้การทรมานเป็นอาชญากรรมนะคะดังนั้นวันนี้เนี่ยเราจึงยังไม่สามารถที่จะเอาผิดกับเจ้าหน้าที่ที่ทำการทรมานประชาชนได้นะคะวันนี้เนี่ยกฎหมายฉบับนี้เนี่ยยังอยู่ในระหว่างการพิจารณาของกรรมาธิการยุติธรรมของสภาผู้แทนราษฎรแล้วเมื่อเกิดการยุบสภาขึ้นเนี่ยการพิจารณาของกรรมาธิการนี้ก็จะส่งไปนะคะเราก็คงต้องตั้งความหวังใหม่ว่านะคะถ้าเรามีการเลือกตั้งเราจะมีรัฐบาลใหม่เราจะมีกรรมาธิการใหม่ที่จะตั้งขึ้นมาแล้วเพื่อที่จะมาพิจารณากฎหมายว่าด้วยการทรมานเขานะคะถึงแม้ว่าเราจะลงนามในอนุสัญญาฉบับนี้แต่มันก็เกิดความล่าช้ามากนะคะในกรรมาธิการเนี่ยก็ยังพบว่าเจ้าหน้าที่หน่วยงานความมั่นคงเองบางคนเนี่ยหรือบางหน่วยงานเนี่ยก็ยังมีความกังวลว่ากฎหมายที่จะบัญญัติให้การทรมานเป็นอาชญากรรมเนี่ยอาจจะส่งผลทำให้เจ้าหน้าที่เนี่ยปฏิบัติการได้ไม่เต็มความสามารถ